Hi, good day. I am Riza Marie Sabado, and for my group's discussion, we will be tackling about the parole rules and supervision. Before we dive into the rules and supervision, it is important to know first what is the definition of parole. Parole, as defined, it is the release of a prisoner from prison after serving the minimum period of indeterminate sentence. The legal basis for this is the Act number 4103, or the Indeterminate Sentence Law, which also created the Board of Pardons and Parole. When we say indeterminate, the cases under this will require the criminal to serve a range of years determined by the judge. A minimum period will be set, and after it, the case will go before a parole board that sets the actual date of release. Moving on, the revised rules and regulations of boards of pardon and parole. For the review of cases for parole, the application that was passed, the cases for parole are then reviewed unless disqualified under Section 15. Under the revised rules and regulations, Section 15, it states the disqualified offenders. Also, the inmate must show that they are serving an indeterminate sentence having maximum period of which exceeds 1 year, pursuant to a final judgment of conviction, and that he has served the minimum period of the said sentence. So there are two things to be reminded of. First, the offender must not fall under the disqualified offenders, and also it must show that he is serving an indeterminate sentence and already served the minimum period of the said sentence. Once the conditions are all good, the parole may be granted to the offender. This shows a reasonable probability that if released, he will be a law-abiding and that his release will not be incompatible with the interest and welfare of society. It is a great way of providing another chance for first-time offenders or even offenders who have committed less serious felonies. That's all for my report. I am passing the stage to further discuss our topic to Ms. Tagadtad.
Good day, I am Cassandra Tagadtad and I am going to discuss the disqualification of parole. So, the following prisoners shall not be granted parole. First, those convicted of an offense punished with death penalty, reclusion perpetua, or life imprisonment. So, those convicted prisoners who commit rape, homicide, or murder. And second, those convicted of treason, conspiracy, or proposal to commit treason or espionage. So the third disqualifications are those prisoners who's convicted of misprision of treason, rebellion, sedition, and coup d'etat. So misprision of treason is that there are persons who conspire to commit treason, and the offender know this and failed to make the necessary report to the government within the earliest possible time. So that is the misprision of treason. Next are those convicted of piracy or mutiny on the high seas or in Philippine waters, meaning those offenders who commit piracy or mutiny outside and within the territory of the Philippines. So they are disqualified for parole. Next are those offenders who are habitual delinquents. Habitual delinquents is defined under paragraph 5, article 62 of our revised penal code. So those who within a period of 10 years from the date of release and from prison or last conviction of the crimes of serious or less serious physical injuries. So those are the crimes of robbery, theft, estafa, and falsification. And for those offenders who found guilty of any of the aforementioned crimes a third time, so they are disqualified for parole. And next, those offenders who escaped from confinement or evaded their sentence, and those who were granted conditional pardon and violated of any of the terms thereof. So those offenders who granted conditional pardon, because privilege is a privilege and it only happens once in our lifetime. So an offenders were disqualified for parole if they already granted the conditional pardon. So that's all for my report, and I am passing the stage to Mr. De La Torre for continuing the discussion.
Thank you, Ms. Tagadtad. Good day. I am Edelbert El De La Torre, and I'm going to continue the discussion about the disqualification of parole as well as deferment of parole when the safety of prisoner, victim, relatives of victim, and witness compromise. So, here are the disqualification of parole. First, those whose maximum term of imprisonment does not exceed 1 year or those with definite sentence. Next is those suffering from any mental disorder as certified by a government psychiatrist or psychologist. Next is those whose conviction is an appeal. Then, last is those who have pending criminal cases. So, let's proceed to the next slide. So, this topic is all about when the deferment of parole happens. So, it happens when the safety of prisoner, victim, relatives of victim, and witness compromise. So it means that if there's a proof beyond a reasonable doubt that the prisoner's discharge on parole will endanger his own life, his relatives, witness, and the community, the prisoner's release will be postponed until the danger is past. So in addition, the main objective of pre-parole investigation report is to assist the correction and effective intervention, offender management, and pre-parole decision. So that's all for my report. I am now passing the stage to Mr. Tangog. Thank you.
Good day everyone. I am John G. Tangog and I will be discuss about the proceedings of the board, particular in the interview of prisoners. First, any board member or government official authorized by the board member may interview prisoners confined in prison or jail to determine whether or not they may be released on parole recommended for executive clemency. Next is the board of its authorized representatives shall interview an inmate who has sentenced to reclusion perpetua or life imprisonment, or whose sentence had been commuted from death to reclusion perpetua. So the board member must interview the prisoners, especially to those prisoners has sentence of reclusion perpetua or life imprisonment. Before an interview, the board may require a prisoner convicted of a heinous crime as defined under Republic Act number 7659 and other special laws to undergo psychological or psychiatric examination. So, the prisoners must undergo first a psychological or psychiatric examination to determine if there's any problem encountered by the prisoners. And if the board finds a need for such examination in the light of the nature of the offense committed or manner of its commission. All for my report. I will be passing the stage to Pendihito. Thank you.
Good day everyone, I'm Kimberly Pendihito, and for today's video I'm going to discuss to you about the publications of those eligible for executive clemency or parole. So I'm just going to explain to you directly what the slide means. So that means that only the board has the right to give the list of names for those persons who are convicted for final judgment or qualified to have their release for parole or executive clemency. But before they're going to fully able to have that, they still need to undergo some processes in order for them to check if they're really capable of being recommended to have the parole or executive clemency. Next slide would be the documents to be considered for the publication of those eligible for executive clemency or parole. So the first document needed is the carpeta. So when I say carpeta, this refers to the institutionalized record of a prisoner and other relevant documents. The second one is the mittimus or the commitment order. And the third one is the prosecutor's information and appellate's court decision of the case of the prisoner. So if we can observe, most of the documents here needed are more of about personal information and record of a prisoner. So the purpose for this is they are been observing the prisoner's character to check if he or she is really eligible or qualified for the recommendation of the executive clemency or parole. So the next slide is that in case the prisoner has one or more co-accused who has been convicted, the board shall consider at the same time the prison records and carpetas of the said accused. So still, the board still need to check the prisoner's record of that co-accused to check if that person is also qualified for executive clemency or parole. That's all for my report, and I'm passing the stage to Mr. Arsenas. Thank you.
I am Kirk Andreas C. Arsenas, and I am going to discuss the special factors in parole. The board may give a special consideration to the recommendation for commutation of sentence or conditional pardon whenever any of the following circumstances are present. First is the youthful offenders. They are given automatically a commutation of sentence or pardon because it is the right of the minor or the youthful offenders. Second is the prisoners who are 60 years old and above. They are given the special consideration because they have no reason to stay in the jail because they have the age of 60 years old and above, and they are old enough. Next is physical disability, such as when the prisoners is bedridden, a deaf mute, a leper, a cripple, or a blind or similar disabilities. Next is D, serious illness and other life-threatening disease as certified by the government physicians. E, the prisoners recommended for the grant of executive clemency by the trial or appellate court as stated in the decision. F is the alien prisoners where diplomatic consideration and similar between nation necessable review. G is a circumstances which show that his continued imprisonment will be inhuman or will pose a grave danger to the life of the prisoner of his co-inmates. And lastly, the H is the such other similar analog circumstances whenever the interest of justice will be served thereby. And that's all for my report. I am passing the stage to Mrs. Casas. Thank you.
Thank you, Mr. Arsenas. Good day, I am Maria Casas, and I am going to discuss the parole supervision and transmittal of release document. Parole supervision. After release from confinement, a client shall be placed under the supervision of a probation and parole officer so that the former may be guided and assisted towards rehabilitation. The period of parole supervision shall be extended up to the expiration of the maximum sentence, which should appear in the release document, subject to the provision of Section 6 of Act Number 4103 with respect to the early grant of final release and discharge. Next is transmittal of release document. The board shall send a copy of the release document to the prisoner named therein through the Director of Corrections or Warden of the jail where he is confined, who shall send a certification of the actual date of release of prisoner to the probation and parole officer. That's all for my report. I am passing the stage to Ms. Cordero. Thank you.
Thank you, Ms. Casas. I'm Pamela Maitzi Cordero, and I will discuss the initial and arrival report. When we say initial report, the parolee must present himself to the probation and parole officer within the period prescribed in his release document. But what if he failed to appear? Then, failure to report
within 45 days
from the date he's released from confinement, the probation and parole officer shall inform the board of such failure for the board's appropriate actions, and the parole, he will be called absconding parole. So in arrival report, within 15 working days from the date when the parolee reported for supervision, the probation and parole officer concerned shall inform the board through the technical service of parole and probation administration of such facts. I'm passing the stage, Mr. Palermo.
Thank you, Ms. Cordero. Good day, everyone. My name is Ray Angelo G. Palmero, and I'm going to discuss 3 parole supervisions. First is mandatory conditions of supervision. Second, the review and modification of conditions. Lastly, the transfer of residence. Let's first discuss the mandatory conditions of supervision. It shall be mandatory for a client to comply with the terms and conditions appearing in the release document. The clients or applicants of probation are obliged to comply all the terms and conditions set in the release document, because if any of these documents or conditions are being violated, the court may issue a warrant for the arrest of a probationer. Once arrested and detained, he or she shall immediately be brought before the court for a hearing, which may be informal and summary of the violation charge. Let's proceed to the second, the review and modification of conditions. The board may, upon the recommendation of the probation and parole officer, can revise or modify the terms and conditions appearing in the release document. It is said that the court shall notify either the probationer or the probation officer of the filing of such an application so as to give both parties an opportunity to be heard thereon. The court shall inform in writing the probationer officer and the probationer of any change in the period or conditions of probation. Lastly, the transfer of residence. A client may not transfer from the place of residence designated in his release document without the proper written approval of the regional director, subject to the confirmation by the board. Whenever a probationer is permitted to reside in a place under the jurisdiction of another court, control over him shall be transferred to the executive judge of the court of first instance of the place, and in such case, a copy of probation order, the investigation report, and the other pertinent records shall be furnished. That's all for my report. The next reporter is Ms. Gonzalez. The stage is yours.
Thank you, Mr. Palmero. Good day. I am Rosal M. Gonzalez. I'm going to discuss the outside travel. Outside travel, a chief probation and parole officer may authorize client to travel outside his area of operational jurisdiction for a period of not more than 30 days. A travel for more than 30 days shall be approved by the regional director. Travel abroad and work abroad. Any parole or pardon under active supervision, surveillance, who has no pending criminal case in any court may apply for overseas work or travel abroad. Death of client. If a client dies during supervision and probation, and parole officer shall immediately transmit a certificate true copy of the client's death certificate to the board recommending the closing of the case. That's all for my report. I am passing the stage to Mr. Balangkiao.
Thank you, Ms. Gonzalez. Good day. I'm going to discuss the report of parole and infraction violation. When we say infraction violation, when the client is under the parole supervision program of the Department of Justice and under the parole officer, and the client is committed another crime, then the parole officer should report it immediately to the board. The report created by the parole officer shall be called infraction report because it is a violation in the terms and agreement of the client. After the infraction report has been made by the parole officer, then the board shall receive it. Then the board shall immediately request the arrest of the client because he committed another crime. The effect of recommitment of the client. When the client is recommitment into prison, the client shall serve the remaining unexpired portion of the original sentence which committed him or the client to the prison. If the client did not commit any violation or committed another crime, then there shall be no infraction report shall be made by the parole officer. Mr. Muta, you're up.
So, hello everyone. The last topic that we'll be discussing is on the review of case of recommitted parole and cancellation of pardon or parole. First is the cancellation of pardon or parole. The board may recommend the cancellation of the pardon or cancel the grant of parole of a client if it finds that material information given by said client to the board either before or after release was false or incomplete, or that the client had willfully or maliciously concealed material information from the board. And the next one is the review of case recommitted parole. The board may consider the case of recommitted parole for the grant of a new parole after the latter shall have served one-fourth of the unsafe portion of his maximum sentence. And so that's it for our discussion about the revised rules and regulation of Board of Pardons and Parole. Thank you for listening, and we hope you learned a lot, and have a good day.